Hello everyone, my name is Prajjwal Chauhan and I'm working as a legal intern with LEXIS and Company for the month of July. The topic for this video is breach of contract. The Indian Contract Act 1872 is one of the oldest mercantile laws of the country. The law was enacted on the 1st September 1872 and is applicable to the whole India. The contract defined under Section 2 Clause H of the Indian Contract Act 1872 means any agreement which is enforceable by the law. The contract can be written using formal or informal terms and can be entirely spoken or verbal. A breach of contract is a violation of any of the agreed upon terms and conditions of a binding contract. The breach can be anything from a late payment to a more serious violation such as the failure to deliver a promised asset. Breach of contract is a legal term that describes the violation of an agreement or a contract that occurs when one party fails to fulfill its promises as per the provisions given in the agreement. The fundamentals of breach of contract also involves interfering with the ability of another partner to fulfill his or her duties. A contract can be breached in whole or in a part. Most of the contract end when both the parties fulfill their contractual obligations, but when one of them violates it, breach of contracts happens. Breach of contract is one of the most common reasons why contract disputes are brought to the court of resolution. Now, let's take a look at types of breach of contract. First one is material breach of contract. Material breach of contract happens when a key element of a contract doesn't get fulfilled as agreed. It defeats the purpose of agreement. In this case, mostly the aggrieved party goes to the court and tries to collect damages caused by the breach. For example, if you went to buy the computer but you received only the monitor, it will be considered as a breach of contract and you will be entitled to take a legal action. Second type is minor breach of contract. A minor breach, also known as partial breach or an immaterial breach, where the important aspects of a contract were received, however, the small part of obligations remained missed. In such cases, the suffering party can prove that they are able to pursue a legal remedy if they can prove that the breach has resulted in a financial loss. For example, if a website developer was asked to build a website, but he skipped the page of the team, then this will be considered as a minor breach because nothing significant like company detail, testimonial, etc. have been skipped. Third is anticipatory breach of contract. An anticipatory breach of contract happens when the breaching party notifies the other party that it will not be able to fulfill their obligation by the agreed time. For example, an interior designer finds that it is impossible to meet a deadline, hence stop the work and invest all his or her resources into a new project. The party can take a legal action against the architects. Fourth is actual breach of contract. An actual breach of contract happens when a person fails to meet the certain obligations stated in a contract, complying with authoritative time constraints to finish non-performance. For example, Shyam enters into a contract with Ram and promises that he will deliver 30 bags of cotton on 12th February 2021, but on the scheduled day, he fails to deliver the same. This is an actual breach of contract. Now, let's take a look at breach of contract and its remedies. Under Section 73 of the Indian Contract Act 1872, when a contract is broken, the party who suffers from the breach of contract is entitled to receive from the party who has broken the contract compensation for any or damages caused to him, which naturally arose in the normal course of things from the breach of contract. The party knew when they made the contract to be likely to result from the breach of it. Section 73 of the Indian Contract Act 1872 also mentions that the damage is only payable if the loss has occasioned by the breach. No loss from the breach automatically leads to any damages. Compensation is not paid for any remote or indirect loss or damages sustained because of the breach. The section also adds that in estimating the damage of loss for the breach of contract, which exists of remedying the inconvenience caused by the non-performance of the contract, must also be taken into account. At the date of the breach, the measure of the damages upon a breach by the buyer is the difference between the market price and contract price at the time of breach. Let's take a look at penalties of breach of contract. When the sum payable becomes access to the probable damage or breach of the contract, then it is known as a penalty. In general, there are two types of penalties that the party can receive for breach of contract: legal remedies or equitable remedies. Legal remedies allow the non breaching party to recover monetary or compensatory damages. However, equitable remedies are a particular set of remedies prescribed by a court. Then they are often used to resolve a substantial breach or contract dispute when money damages are considered insufficient to resolve the issue or protect the parties from harm. Also, equitable remedies cannot be availed unless and until the parties show that the legal damages will not be enough to resolve the contract issue. Thanks a lot for listening patiently. Please like, share, and subscribe to this channel.